Okay, welcome back. My name is Tim Hofer. I have the pleasure of moderating this next panel. I am here with the Voices for Liberty program. I hope you are all full from lunch but not sleepy, because this will be a fun one. We are talking about Katie's paper, Free Speech, Fighting Faiths, and None, How the First Amendment Came to Protect Freedom of Conscience for All. So we're going to do this similar to the last panels. We're going to let Katie take a few minutes to tell us about the paper, and then our other two respondents get a chance to respond to it, and then we'll have an open conversation. Katie McCarroll, who's our author today, is originally from the Alabama Gulf Coast. She's been living here in Northern Virginia for the better part of a decade, living and working and going to school. Where you went here, right? You have your JD from Scalia Law School. Closer. Is that better? Great. So Katie's been here and working. She went to Scalia, spent the last 3 years studying and litigating freedom of conscience issues. I'm laughing because I got to have dinner with Katie last night where she told me about her home life, where she has 2 young daughters, but her bio says that in her free time, she likes to do things, which we all know is a joke. Katie, why don't you get us started? Give us a little bit about the paper, help set it up.
Absolutely. Thank you, Tim. Well, I first became interested in this topic after reading a couple of articles about the rise of the nuns. The nuns are individuals who are self-proclaimed religiously unaffiliated. So we're talking about individuals who are either atheist, agnostic, or nothing in particular, which is where the nun moniker comes from. And many of these articles were speculating and on where these nuns came from, because going back to the early 1970s, religiously unaffiliated individuals only accounted for about 5% of the population. But today, that number has increased dramatically to nearly 30% of the population. So the question was, well, where did all these nuns come from? And, some commentators speculated that it was just lack of changing beliefs or social changes, political changes, or even technological changes that inspired these religious nuns. But it occurred to me that an underlying precondition for even being able to make the declaration that you are religiously unaffiliated was reliant on the free speech protections of the First Amendment. So I decided to do some research into that, which led me to looking into blasphemy laws from the 18th and 19th century and the way that those laws progressed into the free speech rules that we know today. So from colonial times up through the 19th century, to even question publicly a single tenet of the Christian faith could land you with hefty fines, prison time, forfeiture of property, or possibly even death. And while there was some variation in the crime of blasphemy throughout the U.S., essentially it boiled down to 3 elements: speech that reviled Christianity, done with malicious intent, and with a tendency to breach the peace. But what I found when reviewing the cases is that these elements were often collapsed down to the single element of the speech itself. So that basically what the crime of blasphemy amounted to in 18th and 19th century America was questioning Christianity. And it was only Christianity that was protected by blasphemy laws because, well, for a couple different reasons, one of which the courts would repeatedly said that all these other faiths are obviously false faiths, and so therefore you can't blaspheme against them no matter how vile your comments are. Some of the other justifications included the theory that Christianity, it was part of the common law as incorporated, as brought over from England, and that to question Christianity was to question the institutions themselves. For instance, if you had no belief in God, you couldn't be trusted to testify under oath because you had no fear of retribution in the next life for violating that oath. So basically, blasphemy laws in the 18th, 19th century boiled down to a Christian's heckler's veto. So anything that offended or potentially offended Christian hearers was punishable. This started to change in the 20th century with the introduction of the clear and present danger test in 1919. This was still kind of a malleable test, but allowed for some subjective assessment of whether or not there was actually a threat of any sort of breach of the peace. The first instance of using this test was in 1940 with the case Cantwell versus Connecticut, and this was it was a very interesting case. It was 3 Jehovah's Witnesses who were proselytizing on the streets. They brought with them literature and phonograph records, and they would ask individuals that they encountered if they could play for them from these phonograph records. And one of the Jehovah's Witnesses, Jesse Cantwell, approached 2 individuals and played a phonograph record for them entitled Enemies. And in this record called Catholics Instruments of Satan. And the 2 men who were hearing this happened to be Catholics, and so they were incensed and threatened Jesse with bodily harm if he didn't get off the street, which he promptly did without question. But then Jesse and his brother and father were charged with breach of the peace. The Supreme Court threw out the case, in part because Jesse had no intent to, revile Christianity. His intent, as the court saw it, was simply to share his worldview, and that the actual breach of the peace element was not met, because while the hearers were insulted by the speech, no actual violence took place. So we have a movement from, if it's speech against Christianity, it's blasphemy, end of story, to a balancing of both the speaker's right to speak and the state's interest in protecting public peace. From there, the law evolves even further, and in 1950, in a case called Joseph Bernstein, Inc. versus Wilson. This was a case about a movie that was being played in the state of New York that many people found to be offensive to Christianity. And at this point, the court gives absolutely no weight to whether or not the hearer is offended or not, and they say in no uncertain terms that the state has no interest in protecting any religion from speech that it finds offensive. So that was essentially the nail in the coffin for the crime of blasphemy in the U.S. Fast forward to today, and the right to offend is protected not only for religious speech, but for political speech and other speech as well, and at least in the United States. But what we're beginning to see around the world is that there is some backsliding towards using laws that are very similar to blasphemy laws to silence dissent around certain religions. Around 79 countries currently have blasphemy laws, but that's up from 32 countries just a decade ago. So we're seeing an increase in the number of blasphemy laws, and we're not just talking about Middle Eastern or African countries. In Europe, 80% of countries have some kind of law that either prevents religious defamation or religious hate speech, also sometimes referred to incitement to religious hatred. Religious defamation is very similar to blasphemy in the elements of the crime and its function. Incitement to religious hatred is a little more narrow and is only really used to target the most egregious speech that could lead to imminent violence against religious minorities. So, that's kind of the broad overview. There's a lot to unpack. But yeah, I think I'll just leave it there for now so we can get to our my fellow panelists.
All right, well, let's do it. Next up is Ankar Gate, who has one of the coolest titles that I've ever been around. Ankar is the Chief Philosophy Officer and a Senior Fellow at the Ayn Rand Institute. He is their resident expert on objectivism and serves as its senior trainer and editor, where he's also taught for over 10 years at the Institute's Objectivist Academic Center, now called the Ayn Rand University. He's the contributing author to a number of books, most recently on a new book called The First Amendment, Essays on the Imperative of Intellectual Freedom. He's been widely cited in op-eds, radio, TV, you name it, he's been there. And Ankar studied economics and philosophy as an undergraduate at the University of Toronto, worked in the financial industry before ARI, and got his doctorate in philosophy from the University of Calgary. So Ankar, go ahead and...
Okay, thanks Tim. And thanks for having me here today at the symposium, and thanks Katie for an interesting paper. I'm going to offer two sets of comments on two related things. The one is what's the overall purpose of the paper, and then something about some of the more specific, some of the argumentation in the paper. And right now the draft to me reads like it could have two purposes, and I'm not sure which one is sort of what the driving purpose is. One could be it's telling an interesting story about the history of blasphemy cases and some sort of related issues, closely related. And I think of it as both it's free speech and the establishment free exercise clauses of the First Amendment and the interplay between those. And is the basic purpose to tell that story to people who don't know it or don't sort of know it in its details? And there's a tendency to think, well, we had the First Amendment, we had the Bill of Rights, and then we had freedom of speech and freedom of religion in the US. And the actual history is that it's much more hard won and that you had to really fight it. There had to be the legal cases, and you can see a development in the law, which I would think, and I think the papers has the perspective that it's a positive development towards more protection of freedom of speech and free exercise and against the establishment of a church by state or federal governments. So it could be so the primary purpose is just to tell that history in its details. Or is it, and I think of this as a little more ambitious, so it's sort of related, is it to argue that the history shows progress? You describe it in the paper, and you described it here in giving a summary of the paper as an evolution. And typically one thinks of an evolution as a positive direction. It's not de-evolving, it's evolving. So And if that's the focus, that the history is a history of improvement, then I have the question of what is improving? And is it that the decisions are, so the results of the cases that are going to the state and federal, the Supreme Court, is it that the decision is they become more and more in line with how one should actually think of freedom of speech? Is the decision and the reasoning that generating the decisions, are they both improving? So you could say the decisions are more protective of freedom of speech, and the reasoning that's generating the decisions is more protective of freedom of speech. Or you could, and that you could think of as, you can have a conception of what freedom of speech really means. It could be more narrow to say the interpretation of the First Amendment is getting better. Like, they take more seriously the establishment and the free exercises clause. There's a way to read when they're trying to protect Christianity, like, do you know what establishment means? And what free exercise means? And does it really mean free exercise only for Christians? Or does it mean, so is it that they're taking the First Amendment more seriously? And then what would that mean? So that's sort of one set of comments about what is the basic purpose or thesis of the paper. And then on the issue of, if part of what it's arguing is that there is an improvement and it's improving in these ways, I have questions about how you're thinking about that, or how that's being thought about in the paper. And I would put that there's two things that come up in the paper, and it's not clear to me what your sort of perspective or stand on these are. And one I would put as, is part of what's going on in the history that the First Amendment, you could say more broadly, the thinking of the Bill of Rights, but the First Amendment, is part of what's happening that it's thought more and more as an individual right versus requiring a social justification or a social purpose. And the way I think about that is, when I think of it as an individual right, it doesn't mean it's a right possessed by the individual. It means it's a right to protect the individual. As against saying, well, it's good if people have freedom of speech because our society is better if it has freedom of speech. And you can then cash out what it means for the society to be better, but it's a social or a public, or I would put it as philosophically, as a collectivist goal, and rights are a means to securing that. Versus what the Bill of Rights is about is protecting the individual regardless of the social consequences. So, and this, like, for blasphemy and offense, it's a lot of people can be offended, and it doesn't matter. That is, it's not, you're trying to figure out, well, okay, that's a social loss, but there's other social gains. It's that calculation is off the table. And in the paper you quote, early in the paper you quote Madison, and late in the paper you quote Jefferson, both about their support of the First Amendment. And I think these are the two best founding fathers on freedom of speech, and I would put both of them, but for freedom of speech and freedom of religion, that they're individualist, not socialist or collectivist, in the sense of the justification of freedom of speech is that it allows me as an individual to think, to figure out what I value, what I think is true, what I want to do for my own life. So if you take Jefferson as one of the drafters of the Declaration of Independence, it's, I need freedom of speech and freedom of thought and freedom of religion to pursue my own happiness, not for some social thing. It's, I need it to pursue my own happiness. And you could think that part of what's happening in the sort of the case history is it's going from a very social collectivist perspective on the First Amendment to a more individualist perspective. But that's a question I have. Is that part of how you're thinking of what's happening in the decisions? And then another way of looking at it that it's keeping a kind of social focus is of thinking is part of the decisions, and both of these elements might be going on in the judicial decisions. There's a more individualist perspective, and there's a different kind of social perspective, which is, I would put it something like the, and in the paper you bring it up like this, that early on they're thinking of we're a Christian nation. To go from that to we're a pluralist nation, and that's one of the formulations you use later in the paper. And you could think of that as, we're trying to promote the social harmony and the social good. When it's mostly Christians, we don't like these people who are offending Christianity. But when society goes from being dominated by Christians to being much more pluralist, you can't have this protection just for Christian. That's socially, it doesn't produce harmony, it produces more strife. And so we've got to change how we're thinking about the First Amendment. That still all puts it in a social justification. And is it that that's what's going on in terms of the decisions, or are both going on in terms of that there's a more individualist perspective, and there's a perspective that society's changed from being Christian dominated to pluralistic, and so if we're thinking about social harmony, we have to think of that in a different kind of way. And I just say this as a two last points. What you quote from the decisions about this tends to support the view that they're still thinking of it in a social way, but we've gone from it's dominated by Christianity to a pluralist, and so we have to do something different. I'm not a historian, and I'm not a lawyer, but I'm dubious that would be only what is going on, but I think that's part of what is going on. And one of the imports of this, in terms of thinking about it in the present day, is if the social justification is the right kind of justification, then is one vulnerable to the argument of, well, we're becoming less pluralistic and we're having a dominant religion, and then criticism of that dominant religion is that produces a lot of social unrest and so on. So we should move back, in effect, back towards the earlier history because we're becoming less pluralistic. And whether one thinks that's actually true, there's certainly people making that kind of argument. And we know we really are a Christian nation and we have to get back. And is the implication of that then, well, if you look at the First Amendment in social terms, it's, yeah, maybe we need allow fewer offense, dissent, and so on. So I'll stop there.
Okay. Katie, do you want to respond?
Excuse me, yes. So all great points. Let me start with going back to your question about the purpose of the paper, whether it's just telling an interesting historical story, or if we're talking about that the history is showing progress. And for me, it was both. I found just reading these blasphemy cases to be fascinating, and to your point about, we kind of make this assumption that, the First Amendment has been around for 200 years. We've had broad free speech rights for that long, and that actually hasn't been the case. Our modern conception of what it means to have free speech is actually very new in the grand scheme of the history of this nation. And so I think it is important to say, look, it hasn't always been this way, and it was actually speech rights were sharply curtailed in a number of ways, going back to the earliest time in our nation's history. I do think that the progression shows progress. I think it shows an increase in true tolerance for dissenting beliefs and ideas. I think it shows an increase in, again, our individual freedoms and what we can speak about in public, because this is true for religious speech, but it also is true for speech across the board in terms of speech that some might find offensive, because we are in such a pluralist society, regardless of what you say, odds are you're going to offend someone. So if someone's always going to have some sort of, heckler's veto over your speech because they're, even if truly and deeply offended by it, then, no speech is safe. I think that it shows that we just have a diversity of viewpoints in this country that we also didn't have. One of the things that occurred to me in terms of why the early courts ruled the way that they did, for one thing, the First Amendment hadn't been incorporated to apply to the states during that time, because that didn't happen until the 14th Amendment was ratified. So the early cases all involved state courts, and these state courts, played a little lip service to the idea of freedom of speech, but they didn't really have to do more than that. So, and then in terms of your comments about the decisions themselves and whether or not, and the reasoning, I think that I see, and like you said, some of the quotes that I use from the decisions do emphasize the social benefit of free speech as it being, a way of getting at the global truth, as a way of having a better political system, a better social system. These things, we can find the best way to do things if we are able to all say what we think the best ideas are. And so limiting the ideas limits the ability of society to be the best that it can be. So yes, there is a social purpose, but I also think that the First Amendment is an individual right as well. And the phrase that kept popping into my head as I was trying to figure out how to verbalize that is that having broad, robust speech protections are an important piece of individual self-actualization. As you said, life, liberties, pursuit of happiness, we do need free speech to be able to find our own truth in the world, our personal best way of living our best life is benefited by having the ability to say what we think that best life looks like. One more comment, to address one more of your comments. So going back to the social aspect, early in our nation's history, we were predominantly a Christian nation. And so it was easier to suppress those dissenting voices because there weren't as many of them. I think another justification that's sort of underlying the concept of keeping the peace was that the common law that that was imported from England contained some remnants of their history, which involved a lot of bloody confrontations over religious differences, going back all the way back to the Reformation, up to through when colonialization began. Religious dissenters were tracked down in the streets by mobs. They were beaten and hung, and this was not the state doing these things. This was, the religious majority was perpetuating violence on religious minorities. And so one of the arguments was, well, if we just suppress those dissenting voices, we won't have this violence. So that's some of the sort of deep historical justifications for the blasphemy laws in the first place. But then as we move through the cases and we become more modern, we're also moving through not one, not two, but 3 or 4 great reawakenings where you see a proliferation of new Protestant denominations. And so even though there's still mostly Christian voices out there, there's no consensus among those voices about what the prevailing tenets of Christianity ought to be. So then how do you decide which dissenting voices you silence, which sect of Protestantism gets to be the dominant one? And so I think that also fed into some of the changing rationale, was like, that, okay, well, maybe we don't need to silence all these voices because they are pretty close to ours. Maybe we just need to tolerate a little more.
So let's stop you there and give Emerson a
Okay.
chance. And maybe we'll get back to this because there's a lot to unpack there. Your title's not as cool as Onkar's, but it's incredibly impressive, as is your background. So Emerson is a senior staff attorney with the ACLU Speech, Privacy, and Technology Project, where he focuses on First Amendment free speech protections. He's also the previous host of At Liberty, the weekly podcast from the ACLU. Prior to the ACLU, he was a legal advisor at the International Center for Nonprofit Law, where he provided technical legal assistance to civil society leaders, government officials, law students, and other stakeholders from across Africa to improve the legal framework protecting the freedom of association, assembly, and expression on the regional and national levels. That was a mouthful, but really cool. Emerson has a JD from New York University School of Law and a Master's of Public Affairs degree from the Princeton School of Public and International Affairs, and he got to do his undergraduate work at Stanford. Emerson, why don't you give us your take on the paper?
Thanks so much, Tim. Thanks, Katie. Thanks, Onkar. It's a pleasure to be here. At this moment, you can imagine that the ACLU is quite busy, busier than normal, but it's nice to be able to take a moment in the world of ideas and to really look at a paper that I think does something that's my favorite kind of legal paper, where we can take a look at some overlooked cases and give a close look at the context, the historical context, the sort of personal motivations, a deeper dive into what was really behind these interesting cases. So I think the first thing I want to say is thank you for introducing me to this really fascinating history from the 19th century particularly. And for those who haven't read the paper, the second, after the introduction, which lays out some really fascinating statistics about the prevalence of non-religious affiliation or affiliation with no religion at all. And then the second section goes to this dive into 4 different cases of blasphemy cases from the 19th century with which I was totally unfamiliar. And again, I think it's always useful as lawyers, but also I think as interested citizens to think about how these things were done differently at different times. And as Onkar said, it is not the case that the First Amendment has always meant what it means to us now. So I just first thank you for introducing me to this new history. I think also what you do in this paper really well is tell a story of an arc of how things have changed over time, right? And so you're highlighting some pivotal shifts from a time when blasphemy laws were widely enforced. Nobody seemed to really have a problem with it from a free speech or First Amendment perspective. But of course, that is not the reality we live in today. And I think tracing these evolutions, as you described them, and as Onkar said, in both the case law, but also within the case law, both in the rhetoric and the doctrine, I found really fascinating. In particular, you highlighted how the early cases found the need to pay lip service to some free speech principles. So even as they were convicting someone of something totally innocuous, of saying something totally innocuous, but convicting them of blasphemy, many of these decisions include what you describe, I think, aptly as lip service to, well, of course, we're not punishing just any criticism of Christianity. This is far beyond the pale, right? When in fact, maybe they were quoting directly from a Bible passage or something like that, right? So I was really fascinated to see how you teased out these sort of why did they even feel the need to sort of make that disclaimer in the midst of such an egregious opinion? But you really do a good job of highlighting those shifts over time. And then I think the last thing I wanted to highlight in a positive regard was you do a good job of explaining why blasphemy laws are fundamentally at odds with a democratic and free speech favoring system, right? And so the idea that in a pluralist society where we value individual as well as collective social norms, why blasphemy is sort of fundamentally not compatible with this idea. And I think that's an important sort of contribution from a sort of philosophical and doctrinal level. And I think, you mentioned that I'm at the ACLU now. I used to work in international human rights law, but I also am a teacher and mostly litigate First Amendment issues. And so I teach a class called Race in the First Amendment. And so we don't really cover a lot of Establishment Clause or free exercise cases or issues. But this idea of what is offensive speech, who is offended, what is the heckler's veto and how does it function in different circumstances, are all things that we sort of wrestle with a lot in my work, in my cases, as well as in my class. And though blasphemy laws are no longer used in the United States, they're no longer valid in the United States, there is still this idea of community norms, which creeps in different places in First Amendment law. So even when we have these robust protections for free speech, in different ways, this idea that, okay, but this is just beyond what is acceptable in this type, everybody knows that this has gone too far. And there are different ways in which that element of the analysis still exists. And so I think highlighting how that, where that has come from and the implications of who gets to make that determination are still pivotal. I think, one of the areas of my work where this comes up most often is around incitement. And this is sort of, the foundational case here is Brandenburg, which I encourage you to include in the next draft. But sort of, you talked a lot about the evolution towards the clear and present danger, and then Brandenburg is a part of the evolution past the clear and present danger test, where you say that not only do we care about, sort of what it's likely to create in the world, right? Even if there is a clear and present danger, we also insist that if we're going to punish someone for their speech based on somebody else's unlawful action, we're going to also insist that they subjectively meant for this to happen and that it was objectively likely, as well as having it be imminent, right? So we're going to create a three-pronged test to establish a very high bar to say that, okay, there's still some we're going to maintain the idea that there is such thing as words leading to actions, right? And there are some words that we all know are sort of objectively likely to lead to certain undesirable outcomes. So we acknowledge that that is one element, but we also include a subjective element and an imminence element. And so when I think about blasphemy laws or any of the other ways in which we sort of have these communal norms, or we have these communal justifications for free speech restrictions, how are we also thinking about subjective and objective intent and likelihood in these circumstances? So a couple of other things I just want to quickly note that in terms of for the next draft, and I think this is a great. I told my 10-year-old that I get to participate in what they call in his class a writer's workshop. And we get to provide comments, and I said, we're doing it too. Grown-ups get to provide comments too. So in the spirit of a writer's workshop, here are a handful of comments for the next draft. I think I would love to see a stronger connection between these really fascinating sections that you have. One about the sort of normative good that is non-religious affiliation, which I think is a fascinating argument, but as it exists now is not as closely related to the rest of the paper. I think as I said, I think the historical analysis is really fascinating. And then there's also this sort of broader legal analysis of sort of what kinds of legal systems, how do they function in different ways. And I would just like to see a tighter connection between those normative, historical, and legal arguments. though each of them I think on their own is fascinating, as Onkar sort of said. It's not always clear which of those is the dominant narrative in the paper. I think one other thing I would want to highlight is sort of what do we learn from these old cases? I mean, at the risk of sort of offending the hulking figure at the other end of the hall, I'm no originalist. So when I read old cases that were wrongly decided, I'm not in and of itself, that's not shocking to me, right? Like old judges were racist and got it wrong. Got it. Sure. Understood. And so it's fascinating. I learned a lot, and I just want to hear a little more about sort of what it is that we're supposed to take from the focus on those 4 cases in particular, as opposed to, for example, some other pivotal moments that you point to in the, but don't spend as much time on, such as 1950 when you no longer have blasphemy laws, or you talk about actually. I litigate a lot in sort of the educational context, both academic freedom in higher education, but also restrictions on what can be taught and read about in K-12 schools. And in a footnote 50, I have in my notes like 5 times footnote 50, you talk about this evolution that I was really, to be honest, maybe I shouldn't admit this on C-SPAN, but both of you will hear this, that there was actually a case before Barnett about a Jehovah's Witness right to not participate in the Pledge of Allegiance. And that was decided the other way in 1940, right? The Jehovah's Witness lost, and 3 years later, Barnett wins. And it's a fundamental, foundational free speech victory, right? This is a fascinating moment in transition. And so I would like to hear more about I loved the focus on those 4 cases, but footnote 50 could be at least a section, if not a paper on its own. So I'd love to hear some more focus on some of the other pivotal moments. And then last, I don't know how I'm doing on time, but I think more generally I'm interested in, related to that point of sort of why this Jehovah's Witness lost in 1940, but Barnett won in 1943, what, if any, argument, and I think this sort of echoes what we were talking about this morning in terms of correlation and causation and sort of to what extent we're willing to make those types of claims, but you sort of have a thread about religious dissent, blasphemy as sort of any sort of religious dissent. And then there is a sort of argument in the introduction and the conclusion that this is relevant to political speech, which you might think Barnett is more on the political speech side. But there's no actual sort of assertion of what that relationship really is. Is one taking the lead and the other follows? I mean, I'm thinking about in Brandenburg, it was a KKK member, right, whose racist speech set the high water mark for incitement that now we litigate on behalf of activists of all sorts, right? So in that way, people often say sort of white supremacist rights are on the leading edge of many First Amendment cases, right? That's honestly true. In the same way that people were talking about RBG this morning, and many of the early women's rights cases were sort of asserting the rights of men who were being discriminated against by these sex-based classifications, right? So there could be a version that says, well, it might be counterintuitive, but it's really the religious minorities who are opening the door for these political minorities. Maybe that's true, maybe that's not true, maybe that's not even what you're arguing. But it seemed like you were edging in that direction, and I would love to hear more about sort of how you actually think of the relationship between those 2 sets of speech. Thanks.
All right, Emerson, thank you for that, and thank you when you said the hulking figure at the other end of the, and I got nervous. I assume it was with reverence for the Supreme Court justice. I'm not sure how I would have taken it if you ended that with table. Katie, do you want to take maybe just a minute or 2 and respond, and then we'll get to some questions?
Sure. Let's see. Well, to go back to one of your first comments, Emerson, regarding the early courts paying lip service to the idea that free speech is important, and these blasphemy laws don't actually limit calm and well-reasoned, true discussions. I kind of wondered about that too, because as I mentioned earlier, at that time, the First Amendment did not apply to the states, so they really didn't have to say anything at all. So it is, I mean, maybe it was just to reassure themselves that, oh no, we're not really doing what it looks like we're doing, you know, as a cover. I don't know, that's something that I'm not sure how we would access, you know, any explanations on that at this point, but it's definitely something I'll look into. And then I just wanted to comment quickly on your reference to footnote 50, which does talk about the Pledge of Allegiance cases, and the first Pledge of Allegiance case, which the student lost, Minersville School versus Gobitis, and I read a book that included some discussion of why this change happened in just 3 years, and one of the answers is there were different justices. I think there was a turnover of 2, maybe 3 Supreme Court justices in that time, and then also there were 1 or 2 justices who changed their minds. So they voted one way on Minersville and then went the other way in Barnett, and so there was this. You know, there was a dialogue between these justices and some other, you know, legal minds of the time, and they were actually just willing to admit they were wrong, I think, which is kind of an amazing, thing. And then just to quickly address, like, what do we learn from these old cases? One of the things that I took away from this, and I agree, I haven't put it into the writing as well as I would like, is that what we see when we allow it's basically the tyranny of the majority kind of scenario, where the loudest, the most vocal, the most powerful group says they don't like something, and then the courts acquiesce to what they want. What results is silencing of dissenting voices. So that's kind of my big, broad takeaway from looking at those older cases.
All right, so a quick question. Quick question with probably long answers. We've danced around this a little bit. Katie and I were talking about this earlier, but each of the panels that have happened so far today have sort of been on the same vein, on the broader topic about what the Voices for Liberty initiative is about. And then, Ankar, I think you summed it up with a statement that I'm going to make you answer as a question, is this thing has either evolved or it devolves. And when you talk about it in the paper, it seems like it's evolving, but maybe it's not. Maybe what we heard in the first panel on, you know, the rise of anti-Semitism on campus, maybe these things on getting a better sense of where religion falls in free speech, that seems to be changing and sort of morphing. Maybe we can just respond to that, but let's let Ankar and Emerson go first, and then Katie.
I mean, my view of the whole history, including the history around of religion and the First Amendment, is it's broadly evolved, so it's gotten a lot better, but so I think the Bill of Rights should be read as it's about the rights of an individual, so he holds those rights, or the individual holds those rights against the majority, and in that sense, so I agree with many of the decisions. I don't always agree with the reasoning, and the reasoning is often, I think, too social and communal, and that's just, I think, so one might think that's the right perspective on freedom of speech. This is why I would make a distinction. I don't think it's the right perspective on the First Amendment. Sure. And if you think of the reasoning behind the First Amendment, and if you think of people like Jefferson and Madison as part of the architects of the First Amendment, you're just not thinking in social terms. And so there's a way in which philosophically, the whole world moves away from individualism in the 19th and 20th century. So it doesn't surprise me that in court decisions, when they think about rights, they'll think of it in much more million terms than on the Founding Fathers. but they're wrong about that. They're wrong about that, and it's a problem, and it's part of why. So if we talk about the heckler's veto in regard to religion, it's part of why Islam can have a heckler's veto, because it'll be thought of, there's so many of them across the world. If we're concerned with the greatest happiness of the greatest number, which is what Mill's perspective is, look how many people you're offending. And like if you have that kind of socialist perspective, it's, yeah, we are offending a lot of them. And I think the individualist perspective is, it doesn't matter.
Okay.
Sorry, can you rephrase the question again? I'm like, no, I have I'm very fascinated because I have an entirely different perspective, but I think it's a really fascinating distinction that you're drawing.
By design, it was a vague question, so it can be totally different. I think what we're trying to get to is if this paper is showing us that this concept evolved over time, right? The core case has sort of expanded and made it easier. Is recent history going the other way? Are we devolving away from some of that progress that was made?
I don't know. I mean, it's hard to say, but I mean, the question I was hoping you were going to ask is, how do we sort of explain these shifts? Which I think it gets to a little bit what we were talking about in the earlier panel. I think what you were pointing to in terms of a shift from a Christian-dominated society to a more pluralistic society suggests that it's like a demographic issue, right? Like it's really a demographic shift that led to this shift in norms indirectly to protect more speech. Interesting. Fascinating. I haven't thought about it in that way. I mean, and I think there was another sort of theme in the previous talking about causation with the survey data, but whether there's sort of a liberal fog or sort of a general sort of zeitgeist that sort of exists and permeates, and sort of the Supreme Court is, maybe it's in the form of political appointments, right? Like different political choices manifest in the courts, and then we have tangibly different decisions, even over a short amount of time, that are really, we can, whatever we attribute the change in voters' feelings to, if you have an answer to that, I'd be very interested. But whatever that is, whether it's a sort of political fog or whatever the sort of prevailing winds are, philosophically, that's one other answer. I mean, Nadine was saying that she was Professor Strawson was talking about the ACLU and being a champion for the ACLU, and I think I would be remiss if I didn't say, like, there was also an overlap in time of when we started bringing these types of cases and when these rights started being protected and redefined. And so it's not a one-to-one relationship, but that's also a piece of it, right? Like good folks, hard-working folks working on these issues, and they may not be working on another issue in the same way. So I think how we sort of, once you do this really great job of highlighting these shifts, there's the really impossible job of then sort of explaining them.
Katie?
Yeah, just to piggyback on what you just said, Emerson, I think it's hard to nail down one precise reason why things evolve in one direction, because there isn't one reason, right? There's a lot of different reasons. There's social reasons, there's political reasons, there's demographic reasons, there's probably climate reasons and technological reasons for things changing, and so it's fascinating, and I was telling Tim, like you could if you expand it in all directions, you've got a book, but I think, to Tim's question of whether or not we are backsliding into some respects, it's hard to say. I think from what the research that I did, and it plays out a little bit in the last section of the paper as of now, but it needs more development, is the idea that there is this resurgence of these anti-religious hate speech, anti-religious defamation laws around the world that is happening in the name of protecting sensibilities on the one end of the spectrum, and then on the other end of the spectrum is protecting people from actual violence. And so I think that it's going to take some really serious research and looking into to try to find where that balance is, because certainly we want to protect people from violence. But as they've talked about in the earlier panels today, it seems like these hate speech laws actually perpetuate more violence, is I think maybe the correlation that was mentioned earlier. So short answer is I don't know, but it's fascinating regardless.
All right, well, we've got a few minutes left. Let's take some questions from the audience, if there are any. We got.
Thank you. So one just quick observation and then one question. The observation is if you look at the briefs in the Jehovah's Witness case, they're really interesting. One of this something like a parody, but it's not an overcharacterization. One of the summary of argument is the prophet Isaiah says, "Be a light unto the nations." That's what we do when we proselytize. We win. There's no reference to the Constitution. It's just a religious argument straight out. And I think one of the justices, I think Justice Stone, has a note saying this is an interesting religious argument, but we got to make it a constitutional one. The other observation is this history about blasphemy in particular raises questions about not just originalism in its current form, but the developing idea of history and tradition as a way of understanding the original understanding or modifying it. Because the blasphemy cases really do show a pretty strong tradition of regulation of a sort that is quite troubling today. So then what do you do with it? Well, one thing is to invoke the kinds of philosophical background that Jefferson and Madison, but that's a disfavored form of originalism. So I think it's going to be interesting to see if or how the emerging forms of originalism actually end up confronting First Amendment issues.
Thank you. Nadine?
So much. Thank you for a great discussion. Katie, I remember really enjoying your paper when I read it last summer, but I didn't have a chance to reread it before now. So I'm going to mostly be commenting or questioning on what was said orally here rather than on the paper itself. So I'll start by answering Tim's question. I think it's undebatable that the Supreme Court has consistently and increasingly protected freedom for the most controversial speech with very few dissents. And what I find really striking is that the Supreme Court, from left to right, I mean, occasionally you'll get one dissent, a couple dissenters, but basically supporting freedom for kinds of speech that a substantial plurality and even majority of Americans want to censor. I find that kind of fascinating, the disparity between the Supreme Court on the one hand and the public on the other hand. One of my hypotheses is that the justices are familiar with some of the history that gave rise to speech protection, including one of the intervening developments between Gobitis and Barnett was the violence against Jehovah's Witness school children and parents, and they understood that when you give a license to single out, to force them to say certain things, it leads maybe to other kinds of coercion as well. I also, Onkar, I've never even studied philosophy at all, so far be it for me to take issue with a professional philosopher. But my understanding of John Stuart Mill, and I'm just referring to On Liberty and the chapters on free speech, is that he did not acknowledge offended sensibilities as a harm that would warrant restriction, even social restriction, which he was talking about, but which he was focusing on. And I also understand that the modern defense of free speech on the Supreme Court, which started with Brandeis and Holmes, Brandeis, I think, said it even more eloquently than Holmes, that freedom of speech serves both an intrinsic and an instrumental value. And I think both of those themes have come through, each one as independently sufficient for the purpose of protecting individual liberty. But also, in addition to that, the result will be to improve democracy and to promote equality and other ancillary goals. I see a huge strain of individual libertarianism through the Supreme Court's rulings. And Katie, on your interesting point that you come down to this realization that what is being resisted is the tyranny of the majority. I think that's absolutely what has happened with respect to modern free speech jurisprudence, with one exception, or two exceptions, that are interrelated. There is, Emerson is so in 1969, the Supreme Court unanimously adopts the principle that Brandeis and Holmes had set out a long time ago in an ACLU case, unanimously decided, about which Emerson has written a terrific law review article that I highly recommend to you. But the Supreme Court has followed that strict demand that the majority's objection to the message or the values that are reflected in the speech is never a justification for suppressing it, except there is one exception that is still on the books, and that's for obscenity. The Supreme Court has not revisited it since 1963, and it expressly said, 5-4, there's no evidence that obscenity causes any demonstrable harm, let alone intends to or will do so imminently, but it undermines the moral tone of the community. So I think there's a lingering residual enforcement of the same values that gave rise to the blasphemy laws. And then the other related exception is that the broadcast media, and only the broadcast media, have the power to restrict so-called patently offensive and indecent speech. And again, that has not been revisited for many years. That one, I think, does have actually more of an impact. I think, as I understand it, most juries don't want to convict for obscenity, so it probably doesn't have too much of a practical impact. But, Emerson and I, when we go on over-the-air broadcast media, can't even talk about one of the Supreme Court's most famous First Amendment cases, the one, and C-SPAN isn't broadcast, so fuck the draft, right? Not only do you get bleeped, but your host will say, "Well, you're endangering my broadcast license. How can you do that?"
Well, I'm going to cut you off there because because A, I'm nervous, but B, we're over time. Katie, I hope we've given you a lot to think about. Thank you, Katie, and to our panelists very much. This was a great panel.